Join former FBI senior forensic examiners Becky Passmore and Stacey Eldridge as they dig into the world of digital forensics, one bite at a time. Now leading their own consulting firms and educating the next generation of cyber sleuths, these badass babes of digital forensics bring sharp insight, real-world case experience, and a dose of humor to the bits and bytes that build today's investigations. From deep dives into business email compromise and ransomware attacks, Becky's specialty, to cracking the complexities of iPhone forensics, Stacey's obsession, this podcast delivers insider knowledge for professionals, students, and true crime techies alike. If you've ever wondered what really happens when the digital trail is all that's left, tune in and start parsing the truth.
Hello, everybody, and welcome back to another episode of Parsing the Truth, one bite at a time. I am, as always, joined by my co-host, Becky Passmore, and I am Stacey Eldridge. Becky, what are we doing tonight?
We are continuing with your testimony from last week, which we were really getting into it and talking about when you first testified. We were talking about the ISP, the IP addresses. So we're going to jump right back into where we left off last week's episode, and we're going to let you kick it off with what happened next.
The last thing we talked about for everybody, we basically told the jury kind of everything I did, my approach at a high level. And now in the testimony part, we're jumping back into the specific details. And so I'm jumping back into the specific emails. In particular, I'm discussing Incredimail. And I discuss what it is and how it saves emails. And I get into the fact that everything for a folder, such as the inbox that you're used to seeing, is organized into one giant file, even though when you're in your Incredimail program, and I say program because that's what we said 20 years ago. It wasn't an app, it was a program. But even when you're in that program, you're seeing every email separately, and it's organized into the different folders that you choose. And so visually, when you're in your email, as we all know, it's very organized. It's hierarchical, and you can just kind of go down. But I wanted to make sure the jury understood what I was working in looked different, and that was going to cause some of the exhibits to look different by the way I had to do the analysis on this data.
And would you be surprised to know that I did a quick little search and found that you can still download Incredimail? I didn't realize that. And when you're talking about visual, you're not so visual when you're looking at the raw data, correct?
Right. It's going to be just more of the text. And I've manually got to figure out, based on the code that I can see, where the start and end of all of the different emails are. Yeah. And so I'm trying to introduce these exhibits, which is all the emails that the defendant sent from his Dell laptop while he was pretending to be the other employees.
And it's so important for us to understand, and for our listeners to understand, is when trying to introduce exhibits, they must go through someone with the knowledge, the skills, the analysis of that data. So it has to go through someone that is capable of speaking about them in a court of law.
Right. And there's a lot of prep work that we talked about earlier, but even though both of the sides may know about what the exhibits are and they've been on the list, that does not mean that they're automatically go in. And you'll see this as I kind of talk about it. There are some objections that can come up, and that can kind of throw off your rhythm as you're trying to talk about that stuff. So that's just something to be aware of. If you're a digital forensic examiner, you may have your flow interrupted off and on as you're trying to talk about stuff, whether it's an exhibit or you're just saying what the answers are to a question, whether it was from your lawyer or the opposing lawyer.
That's right.
But so getting these exhibits in with the emails that he sent while he was impersonating the other emails, this first email has a subject and a body just containing the word text. And that was from the defendant's personal email, and he's sending it to employee B, their work email, in the evening. And this email was in the sent items as we expect it to be. If somebody is sending something, It's going to be in the sent items. That would be normal and expected. The next email that we talked about and introduced was in his inbox, and it was forwarded from employee B's work email to the defendant. And it had a subject of forward. And when I say forward, I mean FWD. That's how you typically see it abbreviated in those emails when you decide to forward an email you've already received. Now, this forward test email that we have is important, not only because is it just something he sent from his personal email to employee B email, that's their work email. When they send an email, the sender's IP address is going to be in the email that they send. And so in this case, this email sitting in the inbox of the defendant with the subject of forward test has the IP address of the defendant. It's right. Their IP address that we talked about earlier. And I think it's also worth noting that this forwarding occurred just 3 minutes after the test email was sent. And again, this was in the evening, not during normal working hours. And so as I kind of did with you guys, I explained, but in more detail, how replying to emails worked and how forwarding emails worked as well.
Yeah. And after you were able to get these emails in as exhibits, did everything else go smoothly afterwards?
This is where we started running into a lot of the objections as we're trying to get some of this stuff in. We would kind of start and stop. And what we were trying to do is, because as I mentioned earlier, it was one big long file for the inbox. And so for the sake of readability and keeping each individual exhibit short, we chopped up the individual messages into separate exhibits rather than having one exhibit that was hundreds of pages long.
Oh, wow. What happened? Who didn't like that? And why didn't they like it?
So the defense objected, and there was so much kind of going back and forth on this that the jury gets dismissed as we're trying to introduce all of these exhibits.
No, what happens there?
Well, so that's my question. I'm like, what is happening? Why? Because I can't, they're kind of off on the sidebar doing some of this stuff. And I was like, what is happening? Why is the jury leaving? But I was so thirsty at this point. All I could do was concentrate on trying to figure out how to get a drink of water from that silly carafe that they had sitting in the witness stand, as I alluded to in episode 1 of the podcast.
Oh yeah, that was this testimony. Okay.
Yep.
Yeah, I believe that is called foreshadowing.
So it turns out the defense doesn't know or understand where this pile of exhibits is coming from. And he wants clarification on the stringers, the originators, IP addresses, etc. And I want you to remember that I said he wants clarification on stringers. The first couple of emails, we went through the whole rigmarole, and then we wanted to introduce a pile of exhibits all at once without going into all of those details, because it takes a lot of time, and we certainly had a pile of emails to go through. And he told the judge he wanted me to do every single email this way, and there was like at least 8. There was probably more. And so the defense spent a lot of time talking about that in open court at this point while the jury was gone. And so I'm seated right next to the judge. The judge turns to me and starts asking me questions.
Oh my gosh.
Becky, have you ever had a judge ask you questions directly? Because I wasn't prepared for that.
I don't recall if I've ever had a judge ask me questions, but I had a judge ask me if I was related to a specific Passmore.
Okay.
And it was after he released the jurors, and it was just a very interesting conversation because the defendant, the defense attorney, and everyone was still in the room. So anyway,
interesting.
So it's very uncomfortable when a judge starts speaking to you again.
Right. And especially when you're right there. And I didn't know they could do that. I mean, it's their court. I guess they can kind of do whatever they want to a certain extent. But so he's turning to me, looking right at me. He's right there, we're very close. And he starts asking me questions about where these excerpts are coming from and why we didn't just produce the whole file. He's also concerned if we've provided enough context in each of these snippets, these email snippets, to figure out the details, because he wants to make sure it's very clear, who it's to, who it's from, and the dates. And then after this long one-on-one conversation, and I remember the court reporter telling us to speak slower so she could get it all down.
Keep up.
And he says, you know what, I'm fine with the excerpts, because basically, I explained we're only excluding the computer jargon. That was the term he used, and it doesn't impact the content of what the email said or the dates. And so the defense still continues to object. And he says the first two were just tests. And so that didn't really reveal anything. And now we're talking about emails that involve Western Union and Brazil. So he's very concerned about all that stuff. And the judge goes, oh, yeah, I understand your concern now that we're talking about all these different things. And he asks the defense attorney if he'd like to do some voir dire with me to find out, what he needs to find out in order to potentially let these exhibits in.
So now you're under I can never say that.
Voir dire.
That's the word. In the middle of your testimony while the jury is still out.
Yes, fun stuff.
So how does it start for you?
So he's asking me if I know what a stringer is or if I've ever been fishing.
Oh, gosh.
And I'm like, no, and not really, never been fishing. And then the judge pipes in again, and he asked if I've ever worked for a newspaper.
Are you confused?
Yes.
Just like I am right now?
Yes, I'm so confused. And afterwards from, the trusty search on Google, stringers has something to do with, the fishing and the lines and lures and I don't know, something you need to catch a fish, right? And then the newspaper, I guess the stringers are kind of like, I don't know, it kind of sounds like maybe a person who's not actually on staff. I don't think they're highly looked upon or something. I don't really understand any of it, but I was just completely confused. So I'm going in to this voir dire to see if I did my job well. Very confused about fish and newspapers.
Oh my.
And so I think what was happening, the defense thought while I was speaking that I was saying stringer instead of string or strings, as in email strings. Mm-hmm. And so I can't remember if email string was the preferred terminology back then or if there was a particular reason we used that phrase. I don't think I would say that today, but that's what we were saying. Right. So anyways, he's doing his job trying to figure out where each email came from and what, if anything, preceded that content. I guess because he's thinking, the replies and the forwards that I was explaining earlier. And he's asking me, how big is this file? And I say it's massive. And apparently massive is not a good answer for the size of something. So just future note, people, don't say massive. And then he's saying, well, how many pages is it? And I said, I don't know. I didn't print it. I go, but I did notice when I exported everything into a readable format for the case agent that when it was an electronic file, it was hundreds of pages long. And even then I couldn't tell you if it was 200, 400 or 600. I just remembered hundreds. Right. And then I also have to explain that I don't know exactly where this excerpt sat in the Incredimail data file. So I don't know how many pages of content preceded it either. The judge once again starts asking me more questions about what preceded it and why we didn't include it. And basically the answer is, because it's the header info with all the steps it hopped through, some HTML stuff to make the messages look nice. And as we go into later, there's some back and forth. So when you keep replying, the replies have the replies have the replies. So it gets really long. And again, we wanted to just have, this was the content of this new email that the sender is sending sort of situation. And so we go through all of that. And then finally, the judge paraphrases my answer and says, it's clear to him now, the judge. And the defense says, well, it's not clear to me. So he keeps asking me more questions. And then he asked me to put his client at the keyboard. And so I explained again about it being on his computer, his email account, and his password. And then the judge just interrupts and asks the AUSA if he'd like to put anything on the record. And so this kind of, I think, got us to the end because the AUSA really started asking me some good questions to clear it all up. And so I think we're good, but we're not. The defense starts asking more questions about what IncrediMail is and if I used it.
So it seems like you didn't use any of this.
No, I didn't use IncrediMail. I didn't use the app. I don't recall why. I mean, it seems like making the exhibits would have been better if we would have done it in IncrediMail. But the only thing I can think of is I was trying to be like a purist. And since I was dealing with that raw file in FTK and could read through it, I just thought, well, I'm going to export this out to a text file. And so it's all like the same. And I didn't have to want to try to figure out how to get IncrediMail up and running for the case agent who is in a different office 3 hours away and then try to help them use it over the phone. So, I just gave the case agent a text file because they could read it, right? It's a text file. They could see what's meaningful in there. But if I had to try to help them use email, I think we would have just spent so much time trying to figure out how to use email rather than figuring out what was happening.
Right.
And I'm pretty sure if you're an FTK user out there, even though you have one big, huge file, you can highlight snippets of it. And so I'm sure I bookmarked each separate thing, highlighted it, and just, this is this bookmark. So it's all laid out separately in that digital report I would have provided. Because that's just, how I did it. That was my muscle memory of what I had to do every single time when I was bookmarking stuff. I was kind of anal like that.
Right. I understand that. So did any of the exhibits get in?
Yeah, we did end up everything being allowed in by the judge. And he's like, I've noted your objections, defense counsel.
So then does the jury come back and you guys start again?
Yeah, they did say that I had to go back and print everything off anyways and bring it tomorrow. So I say, yep, we'll do that. So now I got to stay overnight so I can do that. Fine. No big deal. And the jury comes back in. At this point, I start discussing the contents of the email strings and the fact that they're replies and that we're very interested in an email string about Rohypnol. And that one email string just going back and forth, that was just like one email was 13 pages long because that email had a product catalog of various drugs that you could purchase. And one of those drugs that you could be was, one of the drugs you could be, one of the drugs you could buy was Rohypnol. And then it also included the price of the different drugs that you could buy and the minimum order. So you had to buy at least $200 worth of drugs.
Oh.
And so the defendant replies and says he wants 200 tabs of Rof and 5 tabs of Cialis and 20 tabs of Zipro. And then he also asked about blood pressure medicine. I don't know how many tabs you need of Rufinol to drug somebody unconscious, but like 250 seems like a lot.
That does. Wow.
And then, you can draw your own conclusions about the fact that he ordered 5 tabs of Cialis and 20 tabs of Zipro, which I believe is an antibiotic, if I recall correctly.
Yeah, I believe so too.
And then, it also includes his total and his payment instructions and all that stuff. And then we introduce another email because remember, we're working to tie all of this stuff together. So there's another email with information about a Western Union money transfer. And this all matches up in the content of the email in terms of where the email said to send the money order and what the email said the tracking number was of the money order, the amounts matching, and who it went to and who it was from. And in that money order, the defendant used his name and home address.
So that Western Union information you're talking about now ties more of those puzzle pieces together.
Absolutely. And in that same email address, he says to send this package of drugs to his office address. And then he also gave his office phone number with the extension to reach him directly in the office.
So it's just continuously tying all of this information together. So what happens next?
Now, here we're trying to get a page in from temporary internet files, and a quick down low on that. The temporary internet files, this is stuff that's going to be saved on your computer as you're browsing the internet. I have to explain this, that it's nothing he saved on purpose, but it's, increasing the performance of your computer, especially 20 years ago when we didn't have high-speed internet and fiber and stuff like that. And so, of course, the defense objects. He's doing his job, and he wants me to explain where it's from and all this stuff, like exactly where it's sitting on the computer and stuff like that. And so I had to stop from reading from it and first explain all the technical stuff from it. And he's trying to keep this temporary internet file out because he was stating this was in there from 15 months ago before the FBI even took anything. And, the judge says, well, the record previously established that you, the defendant, were the only one with everyone's passwords. So he allows it in. And then, I'm finishing explaining what the temp internet cache is. And I go on to describe that this is a page that has information about sexual assault prevention and different date rape drugs.
So does just one temporary internet file get in?
Yeah, there was just the one that we introduced.
Okay.
And, it went to, what is the term the AUSA used? I think just like to the defendant's mindset. It wasn't introduced as fact. It was mindset of the defendant.
Oh, okay.
So we're continuing on. Now we're jumping back to the emails, but now the emails we're discussing are the ones that were used as part of the blackmail with the unclothed pictures, the unclothed pictures of her unclothed in the emails. How do I say that better? Gosh.
Right.
But so it's the pictures of employee A disrobed, and we're discussing this on a PowerPoint. And we're showing the jury these pictures so they can see all of the back and forth in terms of the emails and where we found all these emails. And each jury member has a binder with these same contents. And this eventually leads us into discussing the whole series of the pictures of the victim, employee A. In all of these pictures, she's unclothed and unconscious. And so I'm going through and describing where I found all this stuff. And I state that I found the entire series, over 100 pictures, on his Power Pro laptop. Now, remember, this is his work laptop. And so theoretically, if you're on a sales trip, you're probably taking your work laptop with you.
Right.
And then I also found the entire series on 2 of the thumb drives, but I only found 2 of the pictures on the Dell, and that's his personal computer. And those pictures have been deleted, but I was able to recover some of them from, those 2 from the drive free space. So certainly not active, not visible to the user anymore.
Sure.
Now, it's also important to note that everything on his Power Pro laptop was in the recycle bin. And again, this is his work laptop. He's been fired and he still has it at home after being fired.
Wow.
Now, everything on both of those thumb drives was still active and they were saved in a specific folder.
Okay.
And, when I'm talking about these recovered files that were deleted, and when I say I recovered them, I mean that FTK, did the data carving on the pictures by the headers. It's looking for known pictures or, pictures that are formatted as pictures. It's not doing it through hashing. And even with all of that carving, I only found 2 files. And the way I typically approached a case was, I'm going to look through the stuff that is active, recycle bin, stuff that the tool is showing me without having to go through and data carve for headers. And then when I'm not expecting to see what I want to see, then I'm like, okay, I'm going to go through and data carb at this point. And maybe sometimes I've seen what I want to see, but maybe I think there might be more, and then I'll go in data carb. It's just sort of a case by case basis of what you need to do. Some people may data carb every single time, but that adds a lot of time and overhead and more things to go through. So it's kind of like in your last case that we talked about, how much evidence do you need? Because there's certainly a lot of cases we've got to get through.
Right, right. And so now I see why the AUSA just had you lay some very general foundational work, right? Trying to set the stage to talk about the items that are going to be relevant and to introduce these exhibits. So this being some of the most crucial evidence in the case, and it relates to deleted files.
Yep.
And the whole series is actually in the recycle bin. That's pretty fascinating.
Yes. And, we're continuing to tie it all together. And I think it's telling that, like, on the work laptop, it's all sitting in the recycle bin. So, it sat in that laptop at some point, and then he deleted it, but he never emptied his recycle bin. So it's still there. And so it's helping us tie it all together. It's kind of going towards intent. But what I go on to do, what the goal is to demonstrate that he definitely had all of those pictures on his Power Pro work laptop. And he also had them on both of the thumb drives, even though he went through the motions of deleting them off of the Power Pro laptop, which then sent them to the recycle bin. And we also showed that he had at least 2 of the files on the Dell at some point. And this is important to note because these 2 photos, even though it's just 2, was 2 of the 3 photos that were attached in the email that he sent from his personal email on his Dell computer to employee B. So again, we're tying these pictures that are like, they're everywhere on everything that he has, including the Blackmail emails. And so we're continuing to introduce photos. We're introducing them. The jury is looking at them. Now, I can't remember if all of the photos were being displayed in the courtroom as they were being published or not. I can't remember that. The attorneys are normally really very sensitive about these things and doing it in court the right way. And generally, there's only so much of this stuff that they can/need to show in open court. And because you have to remember, the victim is in the courtroom. Anybody can come into the courtroom.
Right.
So, per usual, they probably just showed a few up on the big screen, and then everything else is in that binder for them to look through as I'm talking about it. And so as I'm talking about all these different photos, the jury's flipping through the binder and looking at everything. And I'm speaking to the jury because they're the people that need to understand this. I'm gauging them for understanding. And this is when I'm starting to see people cry. People in the jury are crying. People in the courtroom are crying. And, and some of this includes the victim. And I'm not sure, there's people in the front, which are definitely more closely related to the case. But again, I'm not sure who everybody is. But so people are crying in the courtroom. Not expecting that either. So at some point while I'm talking about this stuff, the victim gets up and leaves. And I just continue to discuss. And I'm continuing to look at the jury as they're crying. And then eventually the defense asks the judge for a sidebar. So they're talking. I'm taking a little break while they're talking.
And what is this sidebar about this time?
Basically, they're talking about the crying. He's stating that the victim is sitting as close to the jury as she possibly can. And he believes that her crying and leaving the room will prejudice the jury. And that outweighs her right to be in the courtroom. Wow. And so the government responds, and the AUSA says, since there isn't a sequestration order where they make you sit in a room all by yourself and not be in there until you have to testify. So there's no sequestration order. She's entitled to be in the courtroom under the Victim Witness Protection Act.
That's right.
And the judge comments, he's been watching employee A and employee B, and that they've handled themselves with great composure, in his opinion. And when they have left, they've left very quietly, and that they've been sitting quietly, even though that they've had red eyes and tears. And he said, this is to be expected from someone who is in this situation, and that they have every right to be there. And that he also brought up the fact that he thought the government was handling the photos in a good manner, and it was well done.
Oh, wow, that's awesome. Could you hear any of this going on?
No, they were just whispering. This is what I learned through the transcript afterwards. I'm just sitting there again, wondering what is going on. The jury's still sitting there crying, and I'm trying to have a neutral face and drink water, drink so much water.
Oh.
I am so thirsty from all the talking.
Right.
We finally start again, and we're continuing to work more towards tying all of this evidence together. We want to continue to show the relationships between the photos and the devices and the emails. And we also talk about the digital camera a little bit too, and the fact that the user has to select the date and time on the digital camera. And we're doing that because we're going through all of the dates and times on these photos. And these photos are taken on April 12th, late, and then early into the 13th. And I'm also just bringing all that up because I'm discussing the modified access and created dates and times, and showing when they were saved on the Power Pro on April 13th. So again, the same date as some of them were taken, or the day after.
Right.
And then I go on to continue that, that their created dates match between both the times on the photos embedded within in the EXIF data, and that they match the created dates embedded on them on the laptop as well. And that they also have a last access date of June 19th, which is the day before the emails were sent. And so again, we're just tying it together to say, hey, this Power Pro laptop was present on the work trip as to be expected. And he copied the photos onto it while he was still on the road. If they were alone, just him and employee A, he would have been the only one to access them and copy them over on the 13th because, well, she was either drugged or, desperately ill in her hotel room all alone.
Right. And that's a logical assumption, since employee A is either unconscious and ill in her hotel room. And there'd be really no reason for her to even have the defendant's laptop.
Right. And I think this is some of the stuff we brought up in the 2 episodes ago when we were talking about like expert witnesses and stuff, and drawing those conclusions and rendering an opinion, because these are the facts. And so this would be a logical conclusion to draw based on everything we know in the situation. And that's something that we can do.
Yeah, absolutely. And then what?
And then I continue kind of to do the same stuff with the dates and times and the pictures. I do that with the Fuji thumb drive. I talk about that they were moved on there on April 29th, and that their modified date was April 12th, and it was expected for that to match.
Right. So did you have to explain why the created date didn't match when the photo was actually taken?
Yeah, I did have to go into the details and explain, even though the photo was taken on April 12th, it didn't have a created date on the thumb drive of that same date, because basically when you copy stuff from one place to another, the date that you put it on that drive is going to be its created date, regardless of when the file was ever originally created or whenever you took a picture. And so I explained how that was logical, but the important thing to note on this was that the modified date still matched the created date of the photo. And that was the date in question, on the sales trip.
Right.
We move on to the next thumb drive. It has a slightly different created date, but again, it's all, kind of right there. But the part that was interesting about the Sony thumb drive was because all of those photos on that thumb drive have a last access date of June 20th. And that was the day the emails were sent.
Interesting.
So it would be, again, a logical conclusion that he used that Sony thumb drive in his computer, the Dell, on June 20th to send those emails there. We continue to work to link the files between the Dell and the photos, and we talk about the actual link file of one of the photos on the Sony's thumb drive. And it's important because, again, that link file is to a photo that was in that first Blackmail email that only had the 3 photos in it.
Oh, wow. And so what's the date and time of that link file?
It was so good. It was 2 minutes before the email was sent to employee B from the defendant's personal email.
Wow. Wow. Interesting.
And we wrap up by doing the worst thing you can ever do in a courtroom, and that's doing a live demo and showing how a person can see properties of photos and that you can set time zones and things like that on the cyber shot camera, because we had to go in and explain some of that stuff.
Wow. Wow. So this ends your direct testimony from the government. Did you know all that was coming for the most part? Did you expect that in a sense?
Yeah, this was the part that I was really prepared for. I knew kind of what was coming and in what order. We had talked about it, and we had done all this stuff with the exhibits and stuff.
So now you're going to go into the unknown, which is the cross-examination from the defense, which we're going to save that for our next episode.
Yeah, let's save the real hot seat for a whole new episode.
That's right. So thank you for listening. Until then, stay safe, stay sharp, and as always, keep parsing the truth one bite at a time.
If you've enjoyed this episode of Parsing the Truth One Bite at a Time, please head on over to our website, parsingthetruth.com, and click on that donate button and help us raise funds to send one future digital forensic examiner to the IASIS Basic Forensic Examiner Training next spring in Orlando. Thank you.